What's the tea? Welcome everyone to Trust and Trade, your weekly glimpse into hot topics in the world of antitrust and consumer protection.
On behalf of the ABA Antitrust Section's Privacy Legislation Task Force, I want to welcome you to a conversation about the possibility of privacy rulemaking at the FTC, and specifically Magnuson-Moss rulemaking. As you are probably aware, there's been a groundswell of interest in privacy legislation in the past few years. This has resulted in legislation at the state level in California, Colorado, and Virginia, but there hasn't been any federal privacy legislation yet. Congress and others have looked to the FTC and specifically its rulemaking process as one potential way to fill this void. All indications are the FTC Chair Lina Khan and the FTC more generally plan to accept that invitation and begin a rulemaking process on privacy issues. While this process may have been slowed slightly by the delay in confirming Alvaro Bedoya as the fifth FTC commissioner, the Privacy Legislation Task Force thinks that further action on this front is likely in the near future. We have organized a conversation on these topics, and specifically on the Magnuson-Moss rulemaking process, with two of my esteemed colleagues, Kathleen Benway and JeanAnn Tabbaa. Kathleen is a partner at Alston Bird. She has extensive experience at the FTC. She was the chief of staff to 3 directors of the Bureau of Consumer Protection. She was senior advisor to a former FTC commissioner. She was also involved directly in a Magnuson-Moss rulemaking at the FTC. JeanAnn is an associate at Gibson, Dunn Crutcher, where she practices before the FTC and focuses on competition issues. My name is Joshua Wade. I am an associate with McGuireWoods, and I also focus on competition issues before the DOJ and FTC. Before we jump in, we wanted to provide you with a roadmap of our conversation. At the 2-minute mark, we will jump in and start with the sources of authority for FTC rulemaking. Then, at about the 8-minute mark, we will talk about Magnuson-Moss rulemaking in particular. We'll talk about changes the FTC made to the Magnuson-Moss rulemaking process at the 22-minute mark. We'll then have a discussion of the substance of a potential privacy rulemaking at about the 28-minute mark. Thank you for joining us.
Thank you, Josh, for that introduction, and thank you, Kathleen, for being here today. Let's just get right into it. So, what is the source of the FTC's rulemaking authority?
Thanks, JeanAnn. Yeah, well, there were 3 main sources of the FTC's rulemaking authority. There were 3 sources, I should say. There's 2 main sources. The first is Administrative Procedures Act, or APA rulemaking, and that is when Congress has passed a law and specifically provided the FTC with authority to issue rules related to that law. And an example of that is the Children's Online Privacy Protection Act, COPPA. Within that law, the Congress provided the FTC with APA rulemaking authority. The second source, and the one that we're going to spend most of our time talking about today, is Magnuson-Moss rulemaking. And that's within the FTC Act itself. It's Section 18 of the FTC Act. And that provides the mechanism for the FTC to issue rules which define acts and practices which are unfair or deceptive. And then the third is rulemaking under Section 6G of the FTC Act. And so prior to the enactment of Mag-Moss, the Commission did issue substantive trade regulation rules under 6G. However, when Section 18 was passed, that became the exclusive vehicle for the FTC to issue unfair and deceptive practices rules. It's still possible that Section 6A could continue to be used for rules related to unfair methods of competition, but we haven't really seen the FTC use that in decades. I know we're going to jump into Mag-Moss, but just to level set, for the past, I would say 2 to 3 decades, the vast majority of any rules that the FTC passed were through APA and not Magnuson-Moss.
And Kathleen, this is just sort of to follow up on that. My understanding is, there could not be APA sort of privacy rules because there isn't that sort of specific congressional grant, related to the sort of privacy rules the more general privacy rules, I guess I should say, that have been discussed, both in Congress and, at the commission, in contrast to the more specific sort of, rules like COPPA. Is that correct?
Sure. So the only way that the FTC can issue rules under APA is if they have a specific grant from Congress, and that only happens, within a law that Congress passes. So, as you and our audience all know, it's been a long road. We do not have privacy legislation, and so therefore the Commission doesn't have a path to APA rulemaking for privacy. If Congress were to pass a law, they could authorize the FTC to proceed under APA, but they have not done that. And I think the fact that Congress has been unable to pass a privacy law for so long is the impetus for the FTC deciding that they have to take action under their organic, Magnuson-Moss rulemaking process. So sort of separate from Congress. I think they've given up on the idea that a law is going to be passed anytime soon.
And then one other just sort of background question, which might lead into sort of the next topic I know we want to talk about. My understanding is Magnuson-Moss was passed, purposefully to sort of heighten the burden related to rulemaking, to make it, basically to at least establish more procedure around it. Do you have any insight on that, or am I right there?
Sure, that's absolutely true. So Magnuson-Moss was passed sometime in the 70s, and the Magnuson-Moss rulemaking, this provision was added to the FTC Act sometime then, and it was during the time when there was a common feeling that the FTC had overstepped its bounds in a number of areas. And I think the Washington Post famously referred to them as the national nanny, and so Congress, I think, was concerned with that, and as a result, put in some, fairly onerous requirements that the Commission would have to go through in order to pass any sort of rulemaking related to unfair and deceptive practices.
Got it. So I think that leads into kind of our next topic here, which is what are the key steps in the Magnuson-Moss process?
Sure. So I think what would be helpful is to, before launching into that, just to contrast it with what's required under APA rulemaking, just so, sort of to level set and we can understand better the distinction between the two. So just, with APA rulemaking is commonly called notice and comment. And so in it, the agency publishes a proposed rule and seeks comment from the public. And after considering the comment, they issue a final rule, which can be, and in fact has been accomplished in less than a year. Section 18, i.e. Magnuson-Moss rulemaking, on the other hand, requires many steps to issuing a final rule. It's an extremely lengthy process that has averaged in the past at least, taken at least 5 years. I actually worked on a rule at the Commission, the business opportunity rule, and that particular rule actually took 12 years from start to issuing a final rule. And I'm happy to report I did not work on that the whole time, but yeah, it's lengthy. So if we want to talk about sort of what are the key steps, the first thing that has to happen is the FTC publishes an advance notice of proposed rulemaking, or an ANPR, for public comment. And the ANPR details the FTC's areas of focus as well as their objective. objectives, and they seek input on a series of questions that are set out with the purpose of getting information to bolster its argument that an act or practice is deceptive. And I'll give you an example. You know, the FTC has just very recently issued two ANPRs under Magnuson-Moss related to imposter claims and earnings claims. In the earnings claims ANPR, it had 28 separate questions, each of which included some subparts. And what's important is that each question asks for evidence to support its responses. So the FTC is seeking quantitative and qualitative evidence when it lays out its questions rather than anecdotal. And the sort of questions that they ask are meant to get information about the prevalence of a particular activity, the harm that it causes consumers, impacts that it might have on businesses, and also, I think importantly, whether there are already laws that address the harm. And then each of the questions, when the FTC, poses these questions, also asks to provide all evidence to support their answers. And also, in the ANPR process, the FTC also has to provide notice to Congress, to its congressional oversight committees, that it plans to do this.
And Kathleen, I was just going to ask, so who are sort of the interested parties who then can sort of submit that information in response to those questions? Is that, just the public at large, or, would it be the entities that are most likely to be sort of under the regulation?
It's anyone and everyone that wants to respond. So, so of course the entities that would be subject to the rule are, obviously, very interested, and often concerned about how the rule will impact their businesses. The FTC also, hears from consumer advocates. Sometimes congressional members will respond. The general public absolutely also responds to these requests. And the FTC is required to, to consider all of the comments, which, sometimes can run into the, tens of thousands. So it is, a pretty onerous process to, to sort of wade through and analyze all of that information as well. So after the FTC issues the ANPR and the FTC considers the comments, the next step is to publish a notice of proposed rulemaking, and this is another step where it seeks public comment. And so here, the FTC actually sets forth the rule text. So it's the actual language of the rule that they would propose, and they would also include in the ANPR the reasons that they're supporting this rule and alternatives that they may have considered. And they also conduct and include a preliminary regulatory analysis that assesses the costs and benefits of the proposal, as well as like any alternatives that they considered. And at the time of publication, the FTC must have reason to believe that the practices that they're seeking to oversee are prevalent. So they do that, by looking at evidence of, widespread conduct in that area. Another thing that's important is, at every step along the way, the FTC has to make all of the comments that they receive public. So after the notice of proposed rulemaking, the next step is to hold informal hearings, and any interested person can seek a hearing and present their views. And if the FTC determines that there's a disputed issue, it has to allow participants to submit rebuttal evidence and cross-examine other purposes. And the FTC can impose limits on this process, but the limits they impose are the basis for a court review and reversal. And the presiding officer of the hearing makes recommendations as to all the relevant material and evidence that's to be considered. And then the next step is that the FTC publishes a final rule. And the rule has to be accompanied by a statement of basis and purpose that details the prevalence of the practices, how they're unfair and deceptive, and as well as the economic effects the rule could have. So the final rule does also have to assess the rule's costs and benefits and sort of lay out why they've chosen one path over another. And
Kathleen, just to a follow-up question there. So in your experience with the business opportunity rule, I mean, obviously that was an incredibly long period that stretched across, a couple different administrations. Which sort of those steps, were the longest, or the holdups, or, which aspects of that normally take the most time?
Right. So, I think that the steps that take the most time, are, in that case, it was the ANPR. So they published an ANPR. They got a lot of comment and a lot of, concerns from, one particular very large group that would have been subject to the rule. In that case, it was the multi-level marketing industry. I think this was a situation where they received, probably 20,000 comments or more, sort of from, participants in that industry about, what the negative effect it would have. And in that case, it actually resulted in the commission, going back and reconsidering their proposed rule and issuing a revised ANPR. So that process, I think that in that case, that was the, the part that really, took a lot of time. But, frankly, all of these steps take a lot of time. You can imagine that if we're talking about a privacy rule, there's going to be a lot of public comment, public debate about that. And, as I said, the FTC has to, not only review these, thousands and thousands of comments, but analyze them and based on the information that's provided within them, come up with a proposed framework. And certainly that, whatever they come up with is not going, it's going to make, some group likely unhappy. And so, the informal hearing process can take, quite a long time just to even just to schedule those types of things. So if you can just, imagine each of these steps is, months and months, if not years to get through.
And then once once the agency is through them all, it's only at that point, obviously, that they'd be able to bring sort of enforcement actions. Right.
Well, they can't bring enforcement. So you're actually hopping way ahead, Josh. Let me just, no,
I don't mean to bump you off track.
No, not at all. But let me just, go through, the remaining steps so we can get to where you are. But yes, so the FTC publishes the final rule. It's subject to judicial review at that point. Any person can seek review in the DC Court of Appeals within, I believe it's 2 months of promulgation. The court in that case could direct the FTC to consider additional evidence or set aside the rule if it's not supported by the evidence. If if the FTC's procedures in the hearings, for example, limited the rebuttal or cross-examination of particular witnesses, and the court finds that precluded disclosure of material facts. And so, once the DC Court of Appeals makes that review, the court decision is final, subject to only Supreme Court review. So then only after that happens can the FTC actually enforce a rule. And it generally will say, how many days after publication that enforcement becomes effective. When it does have a rule in place, it can seek penalties, civil penalties, which are now up to $46,517 per violation, and it can also seek consumer redress. To get civil penalties under a rule, the FTC has to show that the defendant violated the rule with actual knowledge or knowledge fairly imputed, and also has to, just procedurally, the FTC is required to refer the case to DOJ for review and filing. So those are all of the steps for Magnuson-Moss rulemaking.
So I guess, it sounds like the bottom line is there's a long road, from the beginning of, the ANPR till when, it can begin to be enforced, and, they can begin to get remedies.
Yeah, very, very long road, yes. I will say that in July, the FTC did institute some rule changes that remove some of the steps that had been added to the statutory requirements in an effort to, as they say, streamline the process. And those included the need to have a written staff report and provisions that would allow the presiding officer to compel in-person evidence or in-person attendance and production of documents. And so, those steps, maybe sort of on the edges, they do, streamline it to some extent. It's still a very, very long process. And, I don't think that it would in any way make it likely that this is, that this is going to become, a process that could happen in a year or even two, I think would be pretty hard to believe. And
so, Kathleen and JeanAnn, my understanding, so these were changes to the FTC's rules of practice for Magnuson-Moss rulemaking. So, there's I guess the framework you were just walking through, is at least partially set out in, I guess, the Magnuson-Moss, Act or amendments to the FTC Act, but then the FTC separately has sort of issued these own rules, and they, I guess, have the authority to change those like they did this past summer. Is that your understanding?
Yes. Yes, that's right. So Magnuson-Moss is in, that's Section 18 of the FTC Act. So, I want to make sure people understand that's the same thing, right? But the FTC also issued rules for, for implementing Section 18, and that's in 16 CFR. It's subpart B of the FTC's rules of practice. So yes, and in those rules, if you look at those rules and you sort of compare them to Section 18, they do, follow very closely. It just provides a little bit more information generally, like, the ANPR is required to be, to be published, under the statute. That's a requirement, and in the FTC's rules of practice, Section 1.10, for example, it just provides more information about that. So yes, so you're right. So the FTC can't obviously change the statute. What they did is to revise their rules that they use to implement the statute. And one of the other changes that they made is under the Commission's new rules, the chair sits as the presiding officer for the hearing. They either sit as the presiding officer, or they can appoint who the presiding officer of the hearing is, and that's important because the presiding officer selects which parties are going to be permitted to testify at the hearing. And so, what it does is it, provides the majority of the commission with greater ability to control, like, what facts are considered on the record. Prior to this change, it was an administrative law judge that appointed the presiding officer.
And I understand the minority wasn't thrilled with all of these changes. I think Commissioners Wilson and Phillips wrote a dissent when the majority made these changes, criticizing them for fast-tracking regulation, and their view was that it might harm the fact-finding rulemaking process.
Yes, that's exactly right. Yep.
So, Kathleen, what is your takeaway really with all this recent activity? Does it, in your opinion, your experience, is this going to have a real effect on the timeline and the process for Magnuson-Moss rulemaking?
You mean the changes that were instituted?
Right.
I don't necessarily think that it's going to have a material impact in the time frame that it'll take to get a final rule over the finish line. Maybe to some extent. I think that probably the greater concern is the potential for impartiality, the effects on that, with the change that allows the chair to select the presiding officer. I think that is a very big change. And I think that's the thing that could likely have the most impact on this whole process, and it could lay the groundwork for the rules becoming more political than they have been in the past, I would say.
Got it. That makes sense. So I think then, just to round this out, it'd be good to discuss what do we think the substance of a privacy rule would look like?
Well, JeanAnn, I'm going to throw that back to you. What do you think? Because my crystal ball is a little foggy today.
Yeah,
well,
fair.
I know we had there was an OIRA statement
right.
that I think we, had some reporting had been on that had hinted that, this rulemaking process would have the goals of curbing lax security practices, limiting privacy abuses, and ensuring algorithmic decision-making doesn't result in unlawful discrimination. So, limiting privacy abuses is still a pretty wide, swath of potential conduct that could be regulated. But I do think that gives us, at least, a first indication of the sorts of things FTC might be looking at.
Right. Yeah. And I think that's right. The one thing that I would caution is that, again, like in crafting a rule, again, the FTC has to prove that, that the practices it's seeking are unfair and deceptive, right? And so they have generally in issuing rules relied very heavily on their enforcement record. And so, the FTC can hope to have an extremely broad rule that would cover all of these areas. But again, unless they have to have evidence to show that, the rule is necessary, and it can't be, well, we think this is bad. I mean, they have to have, empirical evidence to prove that a particular act or practice is unfair or deceptive and needs to be covered by the rule.
Right, and that relates to what we discussed earlier about it needing to be shown that it's prevalent, right? And it would be, I imagine, difficult for, to the extent they're kind of considering any sort of novel legislation or things that don't align with past enforcement actions.
Right. I mean, they have to come up with, so they could rely on evidence that they received from other sources, right? Like, let's say, for example, that, the FTC hasn't brought enforcement actions, in a particular area, but, some other agency has. They could rely on that. They can rely on, other research and data. But, I think that, sort of the further they stray from, what they have already sort of set out as unfair and deceptive in these areas, like, i.e. through their enforcement record, the more likely that any rule would be subject to appeal.
Right, which also, kind of goes back to the point that that obviously will just sort of lengthen the process. And I guess there's also always a risk that, as the process gets lengthened, you have a different administration or, a different majority that has a different view, the support of the rule or, things like that could change.
Yeah, yes, absolutely. That's absolutely true. And, and again, I don't think that we should take lightly the judicial review process because, they're going to look at the record and see if, what the FTC is attempting to do is supported and, they could find that it's not. And then the FTC would be, back to square one.
Mm-hmm. I mean, it does seem, and again, these sort of go in more in the crystal ball category than, something concrete that, certainly President Biden, but then also, Chair Khan have set out different enforcement priorities, both in writing and explicitly, but also even just sort of in their actions thus far. And so, obviously Chair Khan has, expressed skepticism, I think would put it, gently towards various, of the large technology companies. And so, I imagine how those companies are using, users' information, would be something that the FTC is at least thinking about. And I know, some of the, interest from Congress that, even reaching out to, the FTC has also sort of identified that as a, potential source of rulemaking. I'm thinking specifically of, I think, Senator Blumenthal this past fall had written, a letter that, a bunch of other senators, including, Senator Klobuchar, Senator Warren, and others had signed on to that had specifically called that out.
Yes. Yeah. I think that's right. I think that, the Congress, has expressed a lot of concern and skepticism over big tech's use of data. So, and as you noted, I think the Biden administration also has, sort of issued some directive to the FTC to use its authority to address these practices. And so, yes, I think that's something that the FTC will seek to, to address. And again, I think that, as we're trying to figure out, what's this rule going to look like? What are the contours? I think that, once the ANPR comes out, that's going to provide a lot of information, at least about what the FTC is considering, right? So recall that the ANPR is just that series of questions that are posed, and so it's only later when they issue an NPR do we see what the FTC is actually, what the requirements and the prohibitions of the rule would be. But I think the ANPR is going to, provide us with sort of like at least, with a roadmap of what the FTC is thinking. And again, like I keep reiterating this, but again, they have to have evidence to support that the practices that they're seeking to regulate are widespread and unfair and deceptive.
Once that's issued, I imagine there'll be a flurry of activity, to put that evidence in, both, defending or, attacking the practices that are targeted.
Right. Yeah. I mean, it'll be questions. So yeah, yeah, I mean, I think we'll see a lot of, obviously this is a rulemaking that's going to get, a lot of comment from, all of the parties that we talked about earlier. And generally the rulemaking, record is open for 60 days. The FTC can extend that if necessary. But I think that, in this case, they'll probably, look to, to stick to the 60 days. So I think that, our listeners really need to be, to be on the lookout for that, ANPR, which I think, can drop like any time now. The FTC has already, notified Congress of its intent to issue, to begin a rulemaking. And so, any interested party should comment on the questions that are posed.
I think those are all the questions we had for you today, Kathleen. Thank you.
All right. Thanks, Gina. Josh.
Yeah, thanks so much for your time. This has really been educational for us, and I'm sure a lot of others that listen.
We hope you enjoyed this episode of Trust and Trade, brought to you as always by the Antitrust Law Section of the American Bar Association. Now you know that's the T.